Hello, and welcome to another session of Williams Mullen Manufacturing Edge, a video series addressing key legal topics affecting manufacturers. I am Rick Matthews. I'm a partner here in the intellectual property section of the Williams Mullen Law Firm, where I help manufacturers protect and enforce their intellectual property rights, including patents, trademarks, copyrights, trade secrets, and the like. I also lead corporate M&A transactions involving intellectual property, in addition to providing legal opinions on the validity and enforceability of intellectual property rights. I am a registered patent attorney and a board certified specialist in trademark law. Our firm, Williams Mullen, focuses on all aspects of intellectual property law, from conception of an invention to enforcing and defending such rights in courts of law around the country. So I'm going to discuss intellectual property issues as they face manufacturing companies in their development of new products, more particularly. And when I talk about manufacturing, what I mean to include is the production of goods and through the use of labor or machines or various processes that may implicate intellectual property issues. So let's start with an overview of intellectual property, which is generally defined as a creation of the mind, or in other words, a product of the human intellect. This includes inventions, artistic and literary works, designs, in addition to the creation of brands or other symbols that are used to identify a source of goods or services. This area of law, intellectual property law, is my focus. In our IP practice, we get to work with a lot of very smart and creative individuals that are solving many of the world's problems. And the preferred way to protect many of these inventions is by getting patent protection. And with patents, they're generally the best means to protect an invention for manufacturers. So this is the best tool I can offer in my practice to clients to protect them against competitors from knocking off their inventions or designs. Of course, the flip side of that same coin is anytime a new product comes to market, we need to assess whether that product might infringe any third-party intellectual property rights. But patents have a limited time of effectivity, and that is 20 years from the life of the original filing of the patent application. So compare that with copyrights for artistic works or other creative inventions, if you will, which lasts 70 years from the date of the author or longer for companies in certain situations. Alternatively, you can compare that with trademarks. They cover the brands that identify the products and the companies that sell them. And they last for as long as the maintenance fees are paid, so essentially forever. And that's similarly true with trade secrets. They last for as long as they're kept secret. So back to patents. Patents are a constitutional right intended to promote the progress of science and useful arts. In fact, the first commissioner of patents was Thomas Jefferson. Patents generally have benefits that include the exclusion of others from practicing the invention. They force competitors to design around a manufacturer's patent. They may create opportunities for licensing and royalty fees. And also they may be used to cross-license against a case where we're defending a patent infringement case. And generally they build value of a company. They create a perception of innovation. And the requirements for a patent are high, and there's a good level of expertise that is required. Our IP team is made up of molecular biology, electrical engineers, physicists, biologists, and chemists alike. But the requirements for a patent are, there's got to be utility, there's got to be something useful there. It's got to be novel, so essentially new and non-obvious. And the patent application itself has to teach an inventor through a written description, its best mode, and how to enable an inventor how to make and use the invention that's being claimed in the patent. So an invention has utility, or it's useful if it provides some identifiable benefit and is capable of being used. Some exemplary subject matter for patenting in the manufacturing space includes products or apparatuses that are actually being made and sold, compositions of matter, chemical formulas, including, for instance, pharmaceuticals. And then, in addition, the process of making those products or the manufacturing method being employed. Or finally, in some instances, the method of use for some of these products. So the process and the methods that we often evaluate could include chemical processes, the actual method of manufacturing, the method of using the product, and sometimes with software applications, a best mode of how the software forms and functions and interacts with the user. So once we hurdle the utility requirement, we next assess novelty, which is essentially whether the invention is new or not. We often assess the invention is new based upon a prior art search. And the same analysis is done with the obviousness analysis. So we look to what is the field of art. This may focus on the records at the USPTO or Patent and Trademark Office, as we shorten it by name, or patent offices around the world. Or we may focus on scientific publications if it's more of a chemical abstract or chemical type invention coming out of a university, for instance. But anything that is publicly known can defeat patentability. So the extent you're having a eureka moment and conceiving of new inventions that may lead to a manufacturing step that would follow, at that time is the best time for us to assess the invention so that we can help decide whether to proceed. But we don't stop there. So aside from protecting the utility or the design of the product through patent law, we also assess trade secrets. So the method of manufacturing or the specific formula that's used may be able to be kept a secret and difficult to reverse engineer. And in those cases, we may decide that a trade secret is a better vehicle for protecting that invention than publicly disclosing it through a patent application. This is obviously limited to the fact that we don't want any employees being able to access the trade secret when they're not authorized or disclosing it outside the four walls of the company. And manufacturers have to be particularly careful with third parties that come into the plant. They may work on machines or may service the plant itself and thereby get access to the inventions or the trade secrets that we want to keep private. So that's a general overview of inventions that can be protected either by patents or trade secrets. But let me talk a moment about trademark law. So trademark law is any word, symbol, or representation that can identify and distinguish a source of goods from another party. It represents the goodwill of a company. And similar to patents, we search for trademarks that may pose a problem if we're selecting a new brand or selecting a unique mark or symbol that will go on a product. And we search the world for trademarks just as we do patents. Similarly, we file trademarks and patents all over the world. So trademarks are very important in advertising. They aid consumers by identifying the source and the quality of those goods. So manufacturers out there who are contemplating a new brand or trademark should put a little TM beside their brand if they've already started using the brand, and soon seek counsel to get a registration before the U.S. Patent and Trademark Office, which itself will garner nationwide protection. So we've covered, at least at the outset, trademarks and patents and trade secrets. The last on the list is copyrights. So copyrights are generally used to protect any artistic or creative work. This could be anything that can be reduced to a tangible medium. So reduced to a CD or a canvas or to a print. It's a very simple and low fee registration process to get protection for a good value, frankly. Copyright protection is often used for photographs, software code and the like. And for a low fee, you can get exceptionally good protection for that code or that image, which includes, if there's some infringement, potentially a statutory damage scheme up to $150,000 for willful infringement and attorney's fees. So it's a very effective tool for a very low cost, and one that we often consider in the full ambit of intellectual property rights that we may consider for manufacturers. So those are the high level issues that we deal with on an intellectual property front in, if you will, putting together a puzzle to protect a manufacturer's rights in IP from start to finish, from the inception and the R&D phase all the way through the launch of a product. But there's some things that I look for in no particular order when I am assessing a new product or design or invention. And the first is the product entitled to some patent or trade secret protection? Can we protect this? Can we either keep it secret, or can we file a patent application based upon a search that affords worthy protection? Is the actual, aside from the product, is the process itself or the method of making that product entitled to some patent or trade secret protection? Are we going to infringe any third-party patents or trade secret rights by using this process or the product itself? And those are significant issues that we assess early on. So can we protect it ourselves, and are we violating someone else's rights? And then, have we chosen a protectable brand for the product, which also does not infringe any third-party rights? And are there copyrightable design elements, software code, or trade dress rights that are available to whatever is being manufactured? So at a high level, we look at the full ambit of intellectual property rights when we're dealing with manufacturers, and there's a lot to consider. We've recently encountered a number of manufacturers that are running into counterfeit products entering into the US market. And we have tools at our disposal that help us stop counterfeit products, whether it be working with customs to prevent importing infringing articles as they're described, or through specific specialized courts, one of which the International Trade Commission I clerked for at a younger age. So the remedies are there and available for manufacturers that are looking to avoid having counterfeit products come into the US. And there's been a lot of it recently post-pandemic with COVID. But aside from counterfeit products, there are a number of intellectual property tools available that we have at our disposal to both protect from the inception through the manufacturing and then the release of these products into the public, any potential intellectual property rights. Again, a protective defensive measure or an offensive measure to stop infringement by third parties. So we look at the intellectual property in the company, we look at the employees, we look at the corporate makeup, and the R&D is certainly a focus that we pay most attention to. So with that being said, for us, we get to see a lot of the latest, greatest products in the market and the fun toys before they ever get to the public. And we get to stand behind these products and defend them. And it's quite a challenge at times, but it's a worthy one and one we enjoy. So that'll wrap up today's video. If you have any questions, please feel free to reach out to me. My information is going to be at the end of this video. And please be sure to visit our IP practice website and our Williams Mullen Manufacturing Edge website that can both be found at www.williamsmullen.com. I appreciate your time, and I hope you have a great day.